Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath of affirmation, announcements by the President.
Honourable Senators, I have granted leave of absence to Senator Sophia Choate, SC, and Senator Deerup Timal, both of whom are ill. Honourable Senators, I am awaiting the instruments of appointment, so with your leave, we will treat with this matter later on in the proceedings.
Petitions, papers.
Minister in the Ministry of Finance.
Madam President, I have the honour to lay the following papers listed on the order paper in the name of the Minister of Finance. The annual report of the First Citizens Depository Services Limited, formerly First Citizens Asset Management Limited, for the year ended September 30, 2019. Thank you, Madam President.
Minister of Rural Development and Local Government.
Thank you, Madam President. I have the honor to lay the following paper as listed on the order paper in my name. The administrative report of the Arima Borough Corporation for the period 2018 to 2019. Thank you very much.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay the following paper as listed on the order paper in the name of the Minister of Education. The ministerial response of the Ministry of Education to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents.
Urgent questions.
Senator Mark.
Thank you, Madam President.
Oh, Senator Mark, just...
Madam President, we asked that I'll be answering question 1. For question 2, we needed to stand down for a while until we get the response.
Sure. Senator Mark.
It's question 1, Madam.
Okay, yes.
I can go to
question number 1.
Has been delayed.
Yeah, the minister has indicated he will answer question number 1.
I will answer question.
I want to go to question number 2.
I stand corrected. Minister Ambrose will answer question number 2.
Sure, so both questions
we find
will be
it urgent
answered.
questions.
Okay. So I am resetting the clock. Senator Mark.
Thank you, Madam President. To the Minister of Energy and Energy Industries, given the Aruba government's denial that it purchased a shipment of fuel from Parliamentary Fuel Trading Company, can the Minister advise whether the Trinidad and Tobago government intends to take any action against the company's board and senior management?
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, let me start by saying, as per the UNC, this question is the definition of mischief. Parliamentary Trading and the government by extension never said that it sold fuel to the Aruba government. We sold fuel to a trader ESUO Shipping, a company registered in Switzerland, whose final destination of the cargo was Aruba. At no point in time did the government say it sold the fuel to the Aruba government. The question that was posed by the Guardian yesterday to the Dutch embassy is also misleading. The embassy response was obviously right. The Aruba government purchased no fuel from Trinidad and Tobago. Yesterday, Parliamentary Trading issued a full-page ad with a press release in all 3 newspapers outlining the details of the transaction. Nothing is clearer than that. To go further, Madam President, in the days when Petrotrin sold fuel to Aruba, it was never even sold to the Aruba government. It was sold to traders because it is a trading business. Governments don't involve themselves in that. So this question, as I said, is the definition of mischief. But let me conclude by saying this mischief has consequences. It is undermining Paria's business. Paria is a trading company. The trading environment is sensitive. Heritage is also a trading company. Heritage has its fuel, its crude marketed through traders. And they are all affecting these companies and the viability of the companies.
Senator Mark.
Madam President, can the minister outline whether Paria Trading Fuel, that according to him sold the oil or gas to this particular company based or registered in Switzerland, can the minister indicate whether Paria Fuel Trading Company conducted a proper due diligence before the gasoline was sold to this company from Europe, based or registered in Switzerland, as you have claimed? Could you tell this Parliament whether
Senator
this
Mark,
was done?
no need to repeat the question. It is not allowed. Next question. You have another supplemental.
Madam President, could the minister indicate exactly and precisely how these questions or questions like these are undermining the viability of Paria Trading Fuel Company Limited?
Minister.
Well, I'm glad for that question, Madam President. Yes. The trading business is a serious business. Confidentiality is the essence of this business. You're trading on a spot market. You're trading on spot purchases. You're trading on long-term contracts. Price is sensitive. Source of fuel is sensitive. Everybody knows of the U.S. sanctions. And by implying that Trinidad is breaking U.S. sanctions, hurts the business. Okay, because all companies are sensitive towards that narrative. And to propagate that narrative is hurting Trinidad when there's absolutely no factual basis to so justify. And it could impact, I'm not saying it has impacted, on Paria's trading business in CARICOM and in the Caribbean. It could impact on Heritage sale of crude. Because who said Heritage sells crude to? Traders. Trafigura, Shell Trading, BP Trading, and a series of other traders in the Caribbean. Heritage fuel goes where? To the U.S. Gulf Coast refinery. Heritage crude goes there. Where does Paria source its fuel from? U.S. Gulf Coast refineries. So the narrative of the UNC is a deliberate attempt to undermine the economy of Trinidad and Tobago.
Always. Next question, Senator Mark.
I think your government is undermining Trinidad.
Senator Mark, next question, please.
Yes, sir?
Senator Mark, next question.
Don't get me upset. Madam President.
Senator Mark, do not waste the limited time that you have. Next question, Senator Mark.
I looked at you, Madam President, and nobody else. Madam President, to the Honorable Prime Minister, in light of recent reports that food cards were being distributed illegally in Tobago, can the Prime Minister advise whether an investigation has been launched into this matter.
Minister of Agriculture, Lands and Fisheries.
Madam President, thank you very much. Madam President, the Ministry of Social Development and Family Services has responsibility for the administration of the food support program nationally, and that includes the temporary food support measures being implemented in response to COVID-19. Madam President, the Ministry of Social Development and Family Services has received no reports relating to the illegal distribution of food cards in Tobago. Notwithstanding, Madam President, all matters of impropriety in the administration of the social support services, in particular those relating to COVID-19, would be thoroughly investigated once these reports are received by the Ministry, and anybody found in wrongdoing would be required to be dealt with by the Trinidad and Tobago Police Service. I thank you, Madam President.
I am hearing someone's cell phone. Can you all not give me a gift for one day, please, and just not let a cell phone go off? That's a gift to me. But can the senator whose cell phone it is, please leave the chamber? Please leave the chamber. You can return in 10 minutes' time. Senator Mark.
Madam President, I thank you. Can I ask the Honourable Minister whether the Ministry of Social Development and Family Services are in contact with their counterparts in Tobago, given the reports that appear in both dailies today as it relates to this illegal activity? Has there been any communication, Madam President, between the parties?
President, I think I've answered that. The Ministry of Social Development and Family Services has received no reports regarding this issue of or allegation of fraud or illegal activity related to food cards.
Senator Mark.
Madam President, given the reports that are in the newspapers, can the Minister indicate whether the Ministry of Social Development and Family Services intends to conduct any inquiry or investigation into those allegations of illegality in respect of the distribution of food cards?
Minister.
Madam President, I'm almost certain that I also answered that part of it. I said, notwithstanding having not received any reports, the Ministry of Social Development and Family Services will investigate all matters that come to their attention, as they have been doing, and would ensure that the appropriate action is taken. Thank you.
Questions on notice. Questions for oral answer.
Leader of Government Business.
Yeah. Madam President, we will be answering question number 78. Am I right? Senator number 106 and 107. Okay, we'll be answering questions 106 and 107, and we ask for a deferral of questions number 78 and 79 for 2 weeks. 76 and 97 for 2 weeks.
Question number 97 is deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 106 to the Minister of National Security.
Minister of Agriculture, Lands and Fisheries.
Madam President, the Government of Trinidad and Tobago, through the Commissioner of Police, has launched the Gender-Based Violence Unit within the Trinidad and Tobago Police Service, and this was done on January 21st, 2020. Madam President, this unit comprised 30 police officers who are distributed through 9 policing divisions, and the unit is tasked with the objective of protecting the lives of all victims of domestic violence. Madam President, in order to achieve the mandate of the unit has implemented several key initiatives, including 1, conducting sensitization and outreach programs relating to domestic violence and breaches of protection orders in particular, in partnership with government ministries, civil society groups, and NGOs. Second, Madam President, the unit is involved in the training of officers both locally and abroad in the area of domestic violence investigations. Thirdly, the unit has employed a case management model in dealing with victims of domestic violence, which ensures follow-up with both the victim and the perpetrator on an ongoing basis. Fourth, the unit has been emphasizing the objective of protection orders to perpetrators and the consequences of breaching such orders. The unit is working with perpetrators, as I've said before, and assist them in understanding their role in the relationship and how they could work towards healthy conflict resolution. Fifth, Madam President, the unit has been assisting victims of domestic violence with ex parte applications for protection orders. And once an application is granted, the police officer serving such an order would then read and explain to the respondent, ensuring that they clearly comprehend the order. Sixth, Madam President, the unit has been providing referrals to victims of domestic violence and in some cases to the offenders, to the Trinidad and Tobago Police Service Community Policing Unit and Witness and Victim Support Unit for psychosocial interventions. Madam President, the unit has also been, 7, providing security to victims of domestic violence, and 8, the unit has been providing transport, safe transport to the victims to places of shelter and other places where they wish to travel without risk. I thank you, Madam President.
Senator Mark.
Yes, thank you, Madam President. Madam President, can I ask the Honourable Minister, through your good self, what impact, if any, these initiatives outlined by the Minister have had in reducing the incidence of domestic violence? Can you share with this Honourable Senate?
Minister.
Madam President, this is one initiative and it is in response to the specific question, but previously I've indicated, and my colleague the Honourable AG, we recently passed the electronic monitoring legislation in this House, which is another element of the response to domestic violence. And throughout that debate, it was emphasized that this electronic monitoring will work for both victims and perpetrators. Madam President, the government has also spoken about changes to the domestic violence legislation, and we are in fact nearing the end of that draft and will shortly lay that bill in the Parliament, and of course expect support from all our colleagues in this House. And the unit itself was formed in January. There's no doubt that it has conducted the outreach that I've spoken about, increasing sensitization, making people more aware of what is available to them. And over a period of time, Madam President, with the combination of all the measures, we expect to see, on the one hand, a decrease in domestic violence, but on the other hand, an increase in the work of the police in ensuring that victims are protected and the law is carried out in relation to perpetrators.
Senator Ma.
Madam President, can I ask my honourable colleague if he can share with us the number of referrals of victims and offenders or accused involved in domestic violence in respect of Madam President, social assistance. Can the Minister share with us what are the numbers involved? Does the Minister have that information?
Senator Mark, I won't allow that question. Next question, Senator Mark. Next supplemental, if you have one.
No, I pause.
Yeah? So next question, Senator Mark. Question 107.
Yeah, question number 107 to the Minister of National Security.
Minister of Agriculture, Lands and Fisheries.
Thank you very much, Madam President. Madam President, in response to part 1 of the question, as of January 31st, 2020, there were 1,421 protection orders in effect. Madam President, in response to the second part, I can easily ask my colleague to take note of what I said in relation to question 106. But Madam President, in addition to what I've already said, I would say that in order to prevent further breaches, the Trinidad and Tobago Police Service has been conducting sensitization activities across the country using the resources of ministries and civil societies and community organizations. And in particular, the police service has been through the unit which was formed in January 2020. The police have been focusing on this issue of the protection order. And when the protection order is granted, that the victim, or in some cases the perpetrator, need to be following up with the police and need to be communicating with the police, in particular when there are issues in relation to personal safety. I've also said, Madam President, that police officers respond to requests for transport when there is an issue of safety in relation to the victims. And one of the main things the police officers have been emphasizing in relation to this, Madam President, is the need for the victims themselves to keep their whereabouts, when they are in a protected environment, to keep their whereabouts a secret, because it has been known, Madam President, in our culture that sometimes the victims themselves reveal their locations and bring harm upon themselves when they do so. So that is something that the police has been emphasizing, that when you are in protective arrangement, it is important that the location is kept a secret, and the police provide support in providing the transport. Madam President, as I said before, when the order itself is granted, the police take it upon themselves to explain to both the victim and perpetrators the terms of the order, the consequences of breaches, and again, Madam President, the need to ensure that both parties adhere to the terms of the order, in particular those provisions which relate to restrictions on the distance that they must keep from each other. Madam President, there are several other measures, some of which I've outlined already, but these are the key measures that are being taken to ensure that the victims are protected and the perpetrators understand their role in relation to the law.
Madam President, I beg your pardon. Can the Minister explain Roman 3 in the context of when would electronic monitoring bracelets be introduced? Because he didn't answer part 3 of the question.
Minister.
President, I apologize to my colleague for not answering Roman 3, which would mean repeating what I said before. Now that the law has been passed, the recent amendment to the law has been passed, I think my colleague, the Honorable Attorney General, has been out there publicly alongside the Minister of National Security saying that the government intends to give effect to the law by implementing the legislation via the use of the electronic monitoring bracelets. And I think that is a commitment that the government has given. It has attracted a lot of mischief from my friends on the other side, of course, but it is something that the government is committed to doing, and that is why we passed the amendment to the legislation.
Senator Mark.
The Honourable Minister referred to a number of community organizations involved in the sensitization program. Can the Minister indicate how many community organizations have been involved in this sensitization exercise, Madam President?
Madam President, the simple answer is that I cannot indicate how many have been involved.
Ask the Honourable Minister to make that information available to this Honourable Senate. And may I ask, Madam President?
That's one thing.
Yeah, well, I just a follow-up in
Yes.
terms of the question. So I'm just asking the formal question. Madam President, can the Minister indicate to us which communities in Trinidad and Tobago have been involved, right, in these sensitization initiatives in an effort to deal with breaches of protection orders? Madam?
So you have to choose one of those two questions. One question was, will the minister provide the names of the community organizations? And then you went on to a second question.
All right,
So
well, that's
choose
the
one.
first question.
The first question. Minister.
Yes, Madam President, within the next week I'll provide the information, which is the list of non-governmental organizations which have participated in the sensitization and outreach work related to domestic violence being conducted by the police service.
No, I think that's it. Yes. No? You have one more.
One more.
You have one more.
Thank you.
Yeah.
Thank you. Madam President, may I ask my honorable colleague and minister whether he would be kind enough to supply this Parliament, possibly in writing if he doesn't have the information, the list of communities that are involved in this very important initiative outlined by the honorable minister. Madam President, you talk about communities and organizations, NGOs. So I'm just asking him, this is how he made
Minister.
a commitment.
Yeah, I get it. Minister.
Madam President, I undertake to do so not out of kindness, but out of duty, sense of duty, because the police service has been doing an outstanding amount of work, and I know that my friend is anxious to see it, because sometimes he has this false impression that nothing is being done. And it's just anxiety on his part, Madam President, to see the great work that the government and the police service is doing, and I undertake to provide him with the list of communities in which this excellent work is being conducted.
Honourable Senators, I have now received the instruments of appointment, so I'm going to treat with that at this stage. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Zola L. Phillips. Whereas Senator Sophia K. Choate, SC, is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola L. Phillips, to be a member of the Senate temporarily, with effect from the 20th of May 2020, and continuing during the absence of Senator Sophia K. Choate, SC, by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, this 20th day of May 2020. To Mr. Josh Drayton. Whereas Senator Derup Timal is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh O.W. Drayton, to be temporarily a member of the Senate with effect from the 20th of May 2020 and continuing during the absence of Senator Derup Timal by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 20th day of May 2020. Honourable Senators, Senators are required to take the oath.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Josh Drayton, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Sure.
You to invoke, as it relates to the first question on the order paper, which was deferred for 2 weeks, Standing Order 27, subsection 15.
So the standing order will be invoked in respect of question number 78. Senator Mark.
Thank you, Madam President. Madam President, in accordance with Senate Standing Order 30 sub 2, I hereby seek leave to raise a matter directly concerning the privileges of the Senate. The matter involves statements made by the Honorable Minister of National Security in response to an urgent question posed at a sitting of the Senate on Wednesday, May the 13th, 2020. As you may recall, the following urgent question, as approved, was read. To the Prime Minister, and I quote, "In light of a recent statement issued by the U.S. Embassy that this country violated the Rio Treaty by allowing the Venezuelan Vice President to land here, has the government initiated discussions with the U.S. with a view to averting any repercussions?" End of quote. The Honorable Minister of National Security gave his response which prompted the following supplemental question, and I quote, Madam President, can the minister indicate whether the government of Trinidad and Tobago is conscious of a statement issued by the U.S. government concerning this country's violation of the Rio Treaty? Is the government of Trinidad and Tobago aware of the issuing of such a statement by the U.S. government? End of quote. The minister accordingly responded, and I quote, as I have said, Madam President, we continue to have open channels of communication. In fact, last week, the U.S. government's head and top diplomat in Trinidad and Tobago, that is, the ambassador, not any underling who may or may not be speaking to the media, the U.S. ambassador had a conversation with me as a representative at the cabinet level of the government. And there were other conversations had, and there was no raising of the breach of any treaty. I would just put the position that seems that all that seems and all that they seem to anchor their mischief in may not be exactly what they believe it to be. End of quote. Subsequent by press release dated May the 19th, 2020, the United States Ambassador Joseph N. Mondello issued the following statement, and I quote, normally I do not comment on private conversations with host government officials. Since the government has spoken publicly about my May 6th conversation with Minister Young, though I wish to affirm that I expressed concern to the minister in that conversation about the consistency of Delcy Rodriguez's visit to Port of Spain with Trinidad and Tobago's obligations as a party to the Rio Treaty. Article 20 of the Rio Treaty makes it unambiguously clear that all measures imposed by the organ of consultation, like the travel restrictions on Mrs. Rodriguez, are binding on all treaty parties, whether or not they voted in favor of such measures. End of quote. From the above, it appears that the minister's response was not merely a contradiction to Ambassador Mondello's statement, but regrettably, it was an untruth seeking to mislead this honorable Senate.
Senator Mark, as per the standing order, your 5 minutes has elapsed. So what I would ask you to do is just go to your very last sentence.
Okay. Madam President, the freedom of speech that we enjoy as members of Parliament is not an absolute one.
Not that one, Senator Mark, the very last sentence.
Okay, thank you, ma'am. The gravity of such an offense is underscored in no less a place than the UK Parliament itself.
No, Senator Mark. I'm actually giving you an opportunity to just finish your very last sentence in what you have. I humbly submit.
Okay.
Yeah?
I humbly submit the above for your determination in accordance with Standing Order 30, subsection 4. I so move, Madam President.
I shall reserve my decision for later in the proceedings.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters be now read a second time. Madam President, Trinidad and Tobago is a twin island state. Land, in its most basic form, comprises our immense wealth. We have a limited resource in this country, and that is certainly our land. Our forefathers have, through their effort, through their enterprise, through their blood, sweat, and tears, engaged in the development of this country by its land resources. It is from land that we get our greatest contribution to our GDP at present, Mr. Vice President, as I welcome you. We get our oil and gas. We get our mining. We get our aggregate for the roads that we drive on. We employ thousands of people. The system of land has been managed over time by a series of laws. Ownership or interest in land is a core requirement of transparency. It is that thing which you can gift to your children. It is inheritance. It is a wealth to the citizens of Trinidad and Tobago. Of course, we have state land, we have private land, we have interest in land of multiple types. In this context, we have a system of registration of interests in land. They exist in a number of laws. Our Real Property Act, or Torrens system, our Registration of Deeds system, our Conveyancing and Law and Property Act. You may have licenses and leases by virtue of oil and gas structures, other dispositions of land. You may have recorded interest. You may have unrecorded interest. You may have an interest in title by virtue of what we call adverse possession, otherwise known as squatting in this country. There is the state land. In all of this, whilst we take steps across the platform to manage our resources in this country, we have as a government brought forward a number of pieces of law to treat with the interest in land. I need only mention the land package, the Registration of Title to Land Act, the land valuation positions, the land tribunal, the amendments to the state liability and proceedings legislation. I need also reflect upon other bills before us now. We will come during the course of next week to discuss the Registration of Deeds package, which is a core concept of reform. But today, I stand before this Honorable Senate, having executed one of the most comprehensive reform packages in the fight against money laundering, corruption, criminality, and terrorist financing, diving at the heart of criminality in this country, coming out of the exercise of reform that we did in our follow the money legislation, in our beneficial ownership disclosure, in the transparency, in the amendments to the money laundering laws of Trinidad and Tobago, coming out of this, there was a stark observation that one of the critical players in the business of land, in the management of this scarce resource, one of the critical players being the real estate industry, remains unregulated in its pure form, completely and totally unregulated, standing only to a voluntary regulation process. Madam President, Mr. Vice President, the closest that we have come to encouraging the organization of the real estate agents in this country, or brokers in this country, has been Act number 10 of 2012. By that act, which was a private act of Parliament, which I participated in when it was being debated, the incorporation of an association to be known as the Association of Real Estate Agents happened. And I want to pay tribute to what is now referred to as AREA, this entity which was born by this act of Parliament, this private act of Parliament, Act number 10 of 2012, because AREA saw itself as a voluntary organizer of the real estate industry. And they have engaged in yeoman service to Trinidad and Tobago. Coming out of that experience and coming out of the desire brought forward by this government and met by the members of AREA, we set upon the development of a regulatory system for real estate agents, which is now before us in this bill. But equally important to the contribution of Trinidad and Tobago and coming out of the march for this legislation was the birth of another agency, the Trinidad and Tobago Real Estate Association, TTREA. And that entity, with its near 200 participants, recently born and organized, is equally deserving of acknowledgement to Trinidad and of acknowledgement by Trinidad and Tobago of a sincerity of purpose in ensuring that there is a joining of the issue that we need to regulate ourselves to better protect Trinidad and Tobago, to organize the profession that is real estate agents in general, to ensure that client money is protected whilst in the hands of brokers, to ensure that there is a discipline in the profession, there are professional standards, we know what professional misconduct looks like, to ensure that there's transparency in the system through a system of registration, through a system of disclosure, through a continuous education requirement. And I want to salute the players, the movers, the shakers, and the participants across the real estate industry in Trinidad and Tobago. That industry comprises, in terms of its share of the national pie, a contribution of almost 2.1% of our GDP. That association is intimately involved in the transactions at the Registrar General. We at the Registrar General's office, wearing the hat as Minister of Legal Affairs, I can tell you, we register approximately 27,000 deeds a year. So 27,000 instruments pass title in this country a year. But that is not to say there are only 27,000 land transactions, because it doesn't take care of tenancies, of leases, of other dispositions of interest in land. And therefore, I come before the Honorable Senate today with 83 clauses and 2 schedules. And these 83 clauses and 2 schedules are intimately tied into the fact that we have an obligation under the Proceeds of Crime Act in the first schedule for real estate agents to be registered with the Financial Intelligence Unit. That's pursuant to Section 2 of the Proceeds of Crime Act and the first schedule of the Proceeds of Crime Act. And we have an obligation for them to be registered because they treat with land. It ties into our international obligations under the Financial Action Task Force, under the Global Forum, under the United Nations rules and resolutions against corruption. But, Madam President, I can tell you that in 2015, there were only 468 real estate agents registered. Sorry, Mr. Vice President. Today, we have doubled that. We are beyond the double. We're at 1,023 because of an aggressive capture of registration by the government and because of the advocacy of the area, the entity that operates, and now most recently the TTREA, who are encouraging registration. But in Trinidad and Tobago, the records of the Financial Intelligence Unit tell us that in 1 year alone, there was almost $23 billion in suspicious activity in Trinidad and Tobago recorded at the FIU. Let me repeat that. $23 billion in suspicious activity. That's half of our earnings as a country per year. On average, we may earn maximum about $45 billion, now at $35 billion. To have $23 billion in suspicious activity recorded at the FIU tells us that a prudent government needs to extend the regulatory reach into the real estate agents themselves. So what do? We have noted quite significantly that this legislation is required. We engage in a process of consultation with a wide bunch of stakeholders. If you look at area with over 137 members, at last 78 brokers, 112 sales associates, 17 corporate bodies. If you look at TTREA with over 200 members, we've touched and concerned over hundreds of persons, having received comments from them both. We have also received commentary from the stakeholder engagement with the Law Association, with a wide range of stakeholders. We've come today with the bill standing on a number of other laws that we have examined. We've looked at the laws of the Bahamas, Bermuda, Canada, New Zealand. We have looked at a bit of the legislation that has occupied attention in those territories. We've looked at the case law in the Commonwealth. We've looked at the case law in Trinidad and Tobago. And as we've done all of that, we've now produced this legislation which tells us with certainty what we ought to contemplate as good law. Mr. Vice President, may I ask what time is full time? Much obliged. So, very little time. I'm compelled to jump directly to the bill. Mr. Vice President, this bill is divided into several parts. We take it through parts 1 to 12. Essentially, what we are doing is we are in this law, causing an interpretation to be immediately relevant. We say who is a real estate agent, who is a sales associate, who is a broker, who is a brokerage, who is a client, what is client money, what is property, what is the business of real estate. We do that in Clause 3. Very importantly, in Clause 3, we say who's a developer, because developers are persons occupying the category of self-business management. They may not be real estate agents, but they may be involved in land issues of a kind that ought to be identified as well. Very importantly, Mr. Vice President, we say in Clause 5, we say in Clause 4 that there is a disapplication. This law does not apply to state land and state bodies because we deal with the disposition of state properties under the Public Procurement and Disposal of Land legislation. I can tell you that I've sat with the procurement regulator. We have finished the review of the bill. We're settling the regulations now. We intend in a matter of weeks to come and complete the regulations that the public procurement regulator has produced. So there's a disapplication in Clause 4. In Clause 5, we say who may engage in real estate, and we exclude in there certain categories. You're not in the business of real estate if you're acting as a trustee, if you're acting under a power of attorney, under a court order, if you're acting as an auctioneer, if you're acting as an attorney at law, if you're acting for a client in the circumstances of assignee, custodian, liquidator, receiver, etc. And what we do is we also say, very importantly, in Clause 4.2c, Part D, that you're not in the business of real estate if you're dealing with property of which you're an owner or part owner, and in subclause E, if you're a developer. Why? You need to manage that cohort in a different way. What we do next is we define in Clause 6 what a developer must do, And we're effectively in this law saying that the Registrar General must receive applications for registration from the following entities: a sales associate, a broker, a brokerage, and a developer. All of those people must pass through the door and file out a prescribed form, fill it out, file it. In the case of the real estate agents, they're of two types: the sales associates and the brokers stroke brokerages. The sales associate does not handle client money. The broker handles client money. So all brokers are sales associates, but not all sales associates are brokers. The developer is the person who says, I am dealing with this land for myself, I'm not acting as a real estate agent. We put an obligation for all of them to get to the public registry and identify themselves. We, in this legislation, also say that the broker or brokerages, they must be licensed by a process of licensing from a committee. They are licensed, they must have professional indemnity insurance, they must be known. Those aspects are dealt with later in the bill, I'll come to that. But in the sales associate and brokerage positions, first port of call is register yourself. Section 27, clause 27 requires a mandatory membership of all real estate agents into the body called the association. We cause a mandatory registration, just like you have mandatory registration for lawyers, for engineers, for doctors, for land surveyors, for architects, etc. And what we do here is we set out in the registers a private register and a public register. In the private register, your information, which is in clause 8, which is where you submit an AML-CFT-PF questionnaire, anti-money laundering, countering financing of terrorism, and proliferation financing terrorism questionnaire, that stays in a private register accessible to the Financial Intelligence Unit, law enforcement, under a court order. The public register is designed for everything else. So you can have access to the public register, but the private register, which has private issues, is available to law enforcement, basically, or court orders. We set out a system of application. You can either be a person at 18 years old, or you can be a limited liability company, or you can be a partnership, and you must have the prescribed qualifications. What does that mean? The association will come up with what the prescribed qualifications are. There is a transition clause in clause 83, where you will see we are effectively saying you'll have 12 months of operation or a further date beyond that, as the minister may by order grant, or 18 months in respect of a broker. You'll have that time for him to bring yourself onto the system, but it is intended that the association will come to work, the association will comprise itself, the association will populate itself. They will have a president, a vice president, a treasurer, a secretary in accordance with the bill before us, and they will, together with the government in a co-regulatory arrangement, describe what the qualifications are. We, of course, provide for the right of appeal to the High Court. If you are refused registration, there's a process of notification, there's a process of objection time frame, there's a process of knowing what your objector says, answering that, so there's full due process in clauses 8, 9, 10, 11, 12 onward. When we get to 13 and 14, we're describing the facets of private and public registers, the access to the public registers. We're dealing with the obligations that are standard in laws like this, such as clause 17, where they're change in particulars, that they're positive obligations to say what's going on. And then we go through a renewal process. We're saying that these licenses, this registration must be done every 3 years. Why? We've done it for the non-profit organization. Number two, it compels the person who is registered to come forward. If we take the experience from the company's law, if you allow companies to exist in perpetuity as we do, you find that nearly 3/4 of your list is defunct, and you are chasing ghosts. It's how money laundering happens. If you remember the juice can fiasco under the last government, where they used a defunct company to carry nearly $1 billion worth of drugs across borders into the United States of America. That has to be put to an end, and the process of recycling registration is standard now across the non-profit organization regime, etc., etc. We get to the ability of the registrar to cancel registration. Obviously, if the FIU tells you to cancel, obviously, if the committee tells you to cancel, obviously, if there are other requirements, there may be an issue of cancellation upon revocation, upon death, upon surrender. That's in clause 20. We, in part 4, established the Real Estate Agents Association, and I'd like to say this is a core aspect of position. The association has a mandatory provision. You have to be a member of the association. Obviously, that is something which we've looked at from a mandatory imposition perspective, under a 3/5 perspective, whether that was required. I can assure you that that is not the case. I have all of the case law with me here today, including the Court of Appeal of Barbados, the European Court of Human Rights, the several dicta coming out of the Canadian jurisprudence, and of course the Privy Council and the Supreme Court of England. In that mandatory membership, we're hanging our position upon the fact that it is a public body for a public purpose, discharging a public interest. And that rhythm is critical because it underwrites the proportionality. And I'll refer you, Mr. Vice President, for that purpose, to several clauses. Perhaps I may get to it in my winding up because time is short. But suffice it to say, when you look at the functions of the association, you look at the disciplinary committee, you look at all of the aspects together, it's a public body discharging a public interest for a public purpose. And what is the public purpose? The protection of Trinidad and Tobago, the fight against corruption, the fight against financing of terrorism, etc. We get to part 5, which is the Real Estate Agents Licensing Committee. Now, this licensing committee is also relevant to the whole concept of how we manage the disciplinary committee. And the disciplinary committee and the licensing committee, disciplinary committee is clause 54, the licensing committee is clause 30. We have used the Service Commission backing by populating those committees with members of the Judicial and Legal Services Commission, an independent cadre of persons to be appointed by the Judicial and Legal Services Commission. Why? Because they exercise quasi-judicial functions in licensing or in disciplining, and therefore you have to have Service Commission backing if you're going to meet constitutional muster. In this position, you will see that we have had a whole regime as to how it works, how the appointments are qualified, how the members are qualified, how they are revoked if anything happens. And the licensing committee is tied into part 6, where we deal with the licensing of brokers. All brokers have to be licensed. Why? Beginning at clause 40, because you cannot handle client money and not have a license to do it. It is a public good that you are licensed for that purpose, the same way attorneys at law are licensed by virtue of their bar qualifications, or doctors are licensed. You have to have a degree of public responsibility here. We, of course, Mr. Vice President, allow for an appellate process, a move to the High Court. We build in the due process regime in the licensing committee in their activities. And then we tie that into part 7, begins at clause 47, where we deal with professional misconduct. The professional misconduct is critical. Look at what we have in clause 47. If you fail to have your client's consent, you fail to disclose that you are acting for more than one person in the transaction, dual brokerage, dual agents, you misrepresent that you have the license to market the land, you pass yourself off as another real estate agent. All of these are very familiar issues to Trinidad and especially Tobago, where the land title is in jeopardy of uncertainty. Although we have a full mechanism of curing that, which is ongoing right now, the fact is everybody can tell of smartmanism, if I can use that expression here. We have too many smart men in the industry, and for people who value their land, their inheritance, etc., we must protect them from the wolves who are out for their blood. When we look to part 8, the duties and obligations of real estate agents, again, this is critical. What are we asking them to do? To maintain critical documents, survey plans, valuation reports, title information, other particulars. Why? In this country, we have umpteen examples in our courts where people pretend to be someone else. They go so far as to do a deed poll to change their name. They come with false IDs. Not false, in fact, because on the deed poll, someone can change their name to Faris Al-Rawi, get a deed poll, present it, go and get a driver's license, have a picture, name says Faris Al-Rawi, they roll up and they try to sell a property belonging to Faris Al-Rawi, and therefore you have fraud or impersonation or identity theft. And all of these are issues which we seek to capture in the Duties and Obligations, Part 7, beginning at Clause 48 of the bill. Part 9 treats with the Disciplinary Committee. And if we look to the Disciplinary Committee, look at the functions in Clause 54. Again, we use the Judicial and Legal Services appointees exercising quasi-judicial functions. To those who are paying attention outside of this Parliament, this is the reason why we have not populated it with people from the industry themselves, because you have to meet constitutional muster by having people appointed by an independent service commission. In that regard, thank you, Mr. Vice President, it is critical for us to remember that both the Licensing Committee and the Disciplinary Committee must be able to discharge functions without fear of interference. And the interference factor is addressed by taking a service commission, in this case the Judicial and Legal Service Commission, to arrange the appointments as we have set out. Mr. Vice President, Part 10 deals with disciplinary proceedings, beginning at Clause 63 onward. And the disciplinary proceedings at Clause 65 tell us that the committee may reprimand or censure, recommend to the RG that the certificate is suspended, recommend to the committee that the license of the respondent is revoked, but very importantly, at Clause 70, where during the course of proceedings, DC observes or discovers evidence of a criminal offense, it shall immediately refer the matter to the Commissioner of Police and to the Director of Public Prosecutions and inform the RG and the supervisory authority. Who is that? The Financial Intelligence Unit. So we're tying in all aspects of the puzzle. Importantly, we set out the offenses, and then we set out the transition provisions at Clause 83. And the transition is to make sure that we allow the industry to come into compliance. 12 months or such further period as may be extended for the sales associates, 18 months for the brokers or such further period as may be extended for them. We, of course, set out in the schedule the constitution of the association. It mirrors a lot of what we find in the Legal Profession Act. We look to the transition of the first board in Part B. In the second schedule, we look to the list of offenses. We tie it into the Prevention of Corruption, Computer Misuse, Proceeds of Crime, Anti-Terrorism Act, and then we deal with consequential amendments. What does this mean? We have come to this country, we've addressed the criminal justice system, massively expanding the criminal justice system, rapidity, courts, judges, laws, rules. That's good enough. We then came and added bodies to those systems, 516 people in the judiciary, 125 new courts when they begin to open, not including those under construction. We then went in and we said, let's deal with processes. That's where your rules come in. That's where your preliminary inquiries come in. That's where your plea bargaining comes in. That's where your maximum sentence indication comes in. We then added in another layer, which is the fight against crime. We demonetize crime issues in money, follow the money, civil asset forfeiture, explain your wealth, amendments to the Companies Act, introduction of beneficial ownership, demonetization of the $100 bill. We then went into land reform on a physical level by improving the processes at the Registrar General's office. We then went into land title issues, how we record title, how we destroy secrecy, how we destroy beneficial ownership coming to cheat by putting a property in some person's name when it's really owned by someone else. And that property could be shares. That property could be bearer share warrants. This is an entire organism where all of the laws that we have passed at the Attorney General's office, in particular in combination with Ministry of Finance and elsewhere, these laws all work together. This is one piece of the puzzle. It is unacceptable where land is a precious resource on twin islands that you could have an industry that is not regulated at all on a compulsory co-regulatory basis. This stabs at the heart of criminality. This is a fight against money laundering, corruption, terrorist financing, but this also elevates a noble profession of wonderful people that have done yeoman service to this country, persons in the associations that have voluntarily managed themselves. And therefore, Mr. Vice President, it is critical that we hear in this debate any concerns and issues, we iron them out, and we get on with passing good, proportionate law. I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters, be now read a second time. Senator Mark.
Thank you, Mr. Vice President. Mr. Vice President, I'm very happy to contribute to this very important piece of legislation that has been long in the making. And as the AG said, I hope that at the end of the day, we will be able to find consensus in passing a law or a bill into an act that would be proportionate, that would be good legislation, that would be fair, and that would be equitable in the interests of the Trinidad and Tobago population. Mr. Vice President, I was waiting attentively to hear the Attorney General declare his interest in this bill, because there's a concept in this bill that deals with developers. And I can tell you that there are many senior cabinet ministers
Would you give way?
have turned into developers in this country.
Mr. Vice President, I regret. In the House, I declared my interest in real estate and as a developer, and I thank the Honourable Senator for reminding me. I was rushing out of time. I properly declare my interest. I did so in the House on the record on many occasions, and I thank my friend for giving way.
Yes. So I'm happy that the Honourable Attorney General has done that. Because, Mr. Vice President, we have some concerns. I have looked and I've done some research on behalf of the opposition, UNC, which will be forming the next government. And I can tell you, Mr. Vice President, that there are concepts here that I need to have clarified. Mr. Vice President, in the original bill, there was a concept of developers. And during the committee stage in the other place, that concept was transformed and translated and changed. And I'm trying to understand, Mr. Vice President, why a developer that is supposed to be concentrating on land development and its distribution in accordance with the planning and facilitation bill, only land, the development of land, laying the infrastructure, and then disposing by sale to you and to me, which is okay. we have now had a new definition, which means the developer is developing the land, Mr. Vice President, laying the infrastructure. But you know what he's also doing, Mr. Vice President? He's erecting buildings, housing, or houses rather, on the land. And Mr. Vice President, he's also selling to you and me the house or the houses. So the developer is three, like the La Trinity, in one. Development of land, building homes, and also selling homes. And you know what is even more dangerous in this concept, Mr. Vice President? That person does not have to have a license. He is not given, he is not incorporated under that section of the law that deals with receiving a license. But you know who they're asking to be licensed? What is called, Mr. Vice President, someone is called in this legislation, as you know, a real estate agent, which means a sales associate or a broker. That person has to be registered. That person, Mr. Vice President, has also to have a license. How can that be fair? How can a developer sell house, build house, sell house, Mr. Vice President, and he does not require a license? Something is wrong with that. And I'm asking the Attorney General, he being a developer, along with many senior cabinet ministers, I don't know if they're in the right profession, quite frankly. You understand? I don't know if they're in the right profession. But you know, Mr. Vice President, I would ask the Attorney General when we meet at the committee stage to make the relevant changes to ensure that a developer is a licensed person. He cannot be out there just developing houses and selling them. And Mr. Vice President, he is not obligated to renew his license every 3 years because he is given a free pass. That is wrong. And I'm asking the Honorable Attorney General to pay attention to that matter. Mr. Vice President, we have looked at this piece of legislation very carefully. And I can tell you that we have some concerns because we don't understand why this convoluted approach is taken by the government of this country. The AG talked about, that is the Honorable Attorney General, talked about New Zealand, and he talked about Canada. Well, I have looked at New Zealand, I have looked at the Bahamas, I have also looked at New Zealand and Jamaica. So Jamaica, Bahamas, and New Zealand. And Mr. Vice President, this convoluted, complex, and confusing piece of legislation that the government has brought before us, you know, there is no comparison with what exists in the Bahamas. For example, you have an organization called AREA, Association of Real Estate Agents, operating for 30 years in the country. They were incorporated in 2012 by an act of parliament. You know they have no role for AREA in the legislation? In fact, the Attorney General and the government has thrown out 30 years of experience. And the Attorney General is boasting in his presentation that these people work so hard and they make so much contribution and this and that and the other. But if you recognize their services and their contribution, why didn't you include AREA in the legislation? And don't tell me you can't do it. Mr. Vice President, may I advise you that in the Bahamas, there is an organization just like AREA, and they're existing for 50 years. And you know what they did in the Bahamas, Mr. Vice President? They incorporated AREA. the counterpart of area, right, in the Bahamas into their legislation. Why cannot we do that? Why didn't the Attorney General incorporate area into the legislation as the Bahamas did? He didn't do that. You know what he did, Mr. Vice President? He put something called an association of real estate agents, established a board, and then he put his own people on that board as far as I'm concerned. When I say he put his own people, you look at the composition of the board. It is not coming from area. I'm saying, Mr. Vice President, that something is wrong with this piece of legislation. Mr. Vice President, in New Zealand, in Jamaica, in the Bahamas, there are boards established. In the case of the Bahamas, area is the board, is the authority. You know, Mr. Vice President, the different committees that we are establishing under this legislation to do with what? Discipline, to deal with licensing, Mr. Vice President. All of these things are functions and duties of the board. But you know what this government has done in the legislation? They put a committee of lawyers, the majority from the law association, or attorneys at law, I should say, not the law association. And they brought one or two other persons in the picture. So you have about 7 members, but the bulk of them coming from the attorney at law. No experience in the real estate business, Mr. Vice President. I do not know what is their practice, but they are coming to determine whether you should get a license to practice your profession. And they have no linkage with the industry. Why is the government doing this? What is the purpose of this? You bring strangers to judge me. It's like we are in Parliament and I did something wrong and I go on before the Privileges Committee. You bring lawyers from outside to judge me. You can't do that. It is my peers that must judge me. You must judge me according to the rules. And that is what the government has done. That is wrong. And I don't know what is the objective behind it. I don't know what is the objective. But there must be an objective, because the Attorney General is wise enough to know that in the Bahamas, the equivalent of area in Trinidad and Tobago has been incorporated in the legislation. So don't come and tell us in this Parliament it cannot be done. It was done. It is done. It has been done in the Bahamas. So why are you leaving them out? Something is wrong, Mr. Vice President. And when I see this concept of developers, and I see that, Mr. Vice President, imagine I'm a real estate agent, hypothetically. I have to register. So here now, the thing is so convoluted and complex. It is as if they want to frustrate persons in that profession. They tell me, as a real estate agent, if I am one, I have to register. Mr. Vice President, every 3 years I am being told under this law, I have to register. You know, in addition to registration, they put another burden on me. They say, listen, if you are a real estate agent or sales associate or a broker, you must have a license. If I don't have a license, I cannot go and do business with anyone who wants to sell land or sell property or rent property. I cannot be involved unless I have a license. And Mr. Vice President, that license is for 3 years. And the Attorney General and this government is saying, I must be registered every 3 years. So I have to register and I have to have a license. But the developer, who is now dealing with land subdivision and infrastructure and selling land, he is now given the power under this law to do what, Mr. Vice President? He can construct buildings. He can construct housing. And he can now sell directly to the public. You know what, Mr. Vice President? No license for him. So you have a senior government minister who is building houses right now on Picton Road in Port of Spain called Alora. He's a developer. He is able to sell on his own, but no license for him. But the ordinary real estate agent is being called upon by this government if you want to buy or you want to engage in any activities in property arrangements and development and exchanges, you must have a license. Something is wrong with that. And Mr. Vice President, in the legislation that I have looked at, I think it was Jamaica. Once you register, Mr. Vice President, that is it. Either Jamaica or I think New Zealand. Once you register, that is it. You don't have to come every 3 years and register again. So why is the government, Mr. Vice President, doing this? And Mr. Vice President, you know what is even more alarming? The association that is established under the Act in order to run some aspect of the operations of the real estate business, Mr. Vice President, that organization, Mr. Vice President, is not given the power to deal with licensing. They are not given the power to deal with registration. Mr. Vice President, you know who is given the power? The Registrar General. That office holder and that office is swamped. It is drowning in work. And you are giving that office more work when in other jurisdictions, New Zealand, Jamaica, and a place called Bahamas, the board of real estate agents, they are called upon in the law to establish their own registrar, to register all agents, all brokers, all developers. But you know what we are doing, Mr. Vice President? We are putting that power in the hands of the Registrar General's office. Why is that? Why cannot the Attorney General think out of the box? Why is he so trapped in colonialism? This is a colonialist approach. Because you can't have an organization, Mr. Vice President, existing for 30 years, doing great
Senator,
work.
you have 5 more minutes.
Yeah, doing great work in this country, Mr. Vice President. And you are saying that you have no role for them? How can we support the measure in its current form? I want to serve notice on the Attorney General. I will not brief for nobody, area or nobody. But I believe in justice and fairness. I am saying I do not hold a brief for area. But I think that they have made a case. And it is an injustice what we are being asked to do here today. So I'm calling on the Attorney General to be prepared to entertain some serious proposals for amendments to this legislation. Don't foist this on area and don't foist this on the country. It is unfair. And I support the AG on getting at the money launderers, getting at the criminals, getting at all of those people who are money washing. We are all on one page in terms of getting at the criminals. But area, the bulk of the people in area, are they criminals? They are not. They have been doing good work in the country. And therefore, we must give them the kind of recognition that they deserve. Don't tell me you are going to toss them out of the window, the baby with the bathwater.
Senator, my apologies. You finish at 11:42.
Okay. Why? I thought I was moving fast. So that's, yeah, but I am now warming up. So, Mr. Vice President, I really believe that the Honorable Attorney General has to rethink this convoluted piece of legislation that he has brought here. Lest people come to the wrong conclusion that this piece of legislation is designed and conceptualized to deal with a few in this nation at the expense of those persons who have been practicing the profession. And so I want the Attorney General to take account of what we are saying on this very important matter, Mr. Vice President. You know, Mr. Vice President, so as I said, why is the Attorney General ignoring the experiences of Jamaica or New Zealand or Bahamas? Mr. Vice President, we are asking the overwhelmed Registrar General's office to do what? That office is under-resourced, heavily strained, under a lot of strain, I should say, and stress. And they are being asked to do the following, Mr. Vice President, under the proposed legislation in Part 3. They are to receive applications for registration. They are to cause notices to be published in respect of those applications. They are to deal with objections to such applications. They have the power to approve or refuse such application. Why should the Registrar General have that power? What does the Registrar General's office know about real estate? Do they have any experience in real estate? You have to put the people, Mr. Vice President, I am not a lawyer, but the Attorney General is a lawyer. And he knows, Mr. Vice President, that the lawyers have something called the Law Association. And it is the Law Association under their law and the Act of Parliament that incorporated that body. They deal with their affairs. But you want to divorce and sever the real estate professionals from their practice and from their profession and their trade and allow persons who don't know, have no experience, Mr. Vice President.
So, Senator, as much as you have the extra time, what is starting to happen is I've heard point 1, I've heard point 2, and I've heard point 3. And I'm starting to hear point 2 again. So if you have any new points to bring, I invite you now to bring.
Several new points. So I am guided by you. I thought I was just emphasizing these points so that you could understand. But I understand that you are a bit bored, so I am now going to go on to new points. Forgive me, I apologize.
So one of the problems that happens with the new arrangement in this chamber is that I'm noticing senators responding to the chair when the chair is trying to rule. Now, the standing orders dictates that you sit so that the chair can rule. Given the fact that we are at the podium, and that's beautiful, absolutely beautiful. So exactly what Senator Mark just did is what I will ask senators to do when it is the chair standing to rule. Senator Mark, all I'm indicating is if you have a new point, you're invited to bring it forward. Thank you.
Yes, Mr. Vice President, I was going to a number of points, but I was just elaborating as I go along. So the next point I'm raising in terms of Part 3, where the Registrar General is asked to do certain things, is to establish and maintain a register of real estate agents and a register for developers. That's the function of the Registrar General's office. Another function is to cancel or to remove a registrant's name, and of course to deal with renewal of applications for registration under this particular law. Now, Mr. Vice President, I would like to ask the Honorable Attorney General, arising out of this set of functions given to the Registrar General, why not, Mr. Vice President, to the Attorney General, vest the association, and I'm talking about area, with these functions of registration and licensing, Mr. Vice President. why not appoint, Mr. Vice President, a registrar from within the association to maintain the register rather than place that burden on the Registrar General's office? Why are there separate bodies, Mr. Vice President, for registration, for licensing, and for education? Mr. Vice President, these are functions that ought to fall under the umbrella of the board or the authority, and not separate them into separate or different committees, Mr. Vice President. Mr. Vice President, I want to indicate to you that when there's a whole question of re-registration of your license, as the case may be. Now, Mr. Vice President, the bill as it stands makes no provision for re-registration when a person's name has been removed from the register. I would ask the Attorney General to consider including a provision similar to the Bahamas law, Section 21, and Section 21 of the Bahamian law says, Mr. Vice President, and I quote, subject to subsection 5 of Section 17, an individual whose name has been removed from the register may apply for re-registration at any time, and all the provisions of this act relating to registration shall apply to the re-registration of this section. Again, Mr. Vice President, I am proposing for the Honorable Attorney General's consideration this particular amendment, Mr. Vice President. Mr. Vice President, there is a section of the law that we are dealing with that looks at the whole issue of the transitional period, or what is called a transitional clause. I think if you go to clause 83, you will see exactly what I am referring to, Mr. Vice President, as it relates to this matter. And I believe this is an area that we need to revisit, and at least advise the government of ways and means of strengthening this particular section.
Senator, you now have 5 more minutes.
Thank you, Mr. Vice President. Mr. Vice President, I would like the Attorney General to share with us this exercise of the formulation of a code of ethics. My understanding is that AREA, which is the Association of Real Estate Agents, existing for over 30 years in this country, have formulated a code of ethics. And I want to find out from the Attorney General whether in the formulation of the code of ethics that already exists and has been formed and established by AREA, whether the government will be paying attention to those elements comprising the code of ethics in terms of attaching same to the legislation in the final analysis. I also believe, Mr. Vice President, we need to have some amendments to what is called broker and what is called sales associates. So I am asking the Attorney General to consider a definition where we will talk about real estate professionals as a category. And this would include the broker, the sales associate, or any sales associate, they call them rookie, registered and licensed by the board who engages in real estate business on behalf of another person in consideration for remuneration. And that a real estate agent means a sales associate or broker. That is a view and that is a concept I would like the Attorney General to adopt when we get to the committee stage. Because, Mr. Vice President, in the legislation, the sales associate or the real estate agent is being told in this legislation, you cannot handle money. And we are advising the government that that is something that they need to rethink. And that is why we are putting this definition for their consideration, Mr. Vice President. Mr. Vice President, there are several amendments we will also be asking the government to consider to the legislation. Clause 79, we are going to propose some amendments for consideration. Clause 47, 48, 49, 51, 56, 83, 15. We are asking the government, Mr. Vice President, to consider amending the legislation so that we can have, at the end of the day, good legislation, proportionate legislation, fair legislation, equitable legislation, Mr. Vice President, so that all the players involved in the industry would have a sense of satisfaction. Mr. Vice President, I have learned that there are over 700, maybe 800 persons in that industry today. 800. So it's a large amount of persons involved in that industry. So we have to regulate it. We support the regulation, but we are putting forward appropriate amendments in order to strengthen the legislation at the end of the day. So we are serving notice that that is what we will be doing at the committee stage of this particular piece of legislation. I wish to thank you, Mr. Vice President, for giving me the opportunity to make my contribution.
Right, Senator Marks, we will have those amendments circulated prior to committee stage, as agreed.
As instructed, sir.
Senator Sipazad.
Mr. Vice President, thank you for the opportunity to contribute to the debate on the bill, the Real Estate Agents Bill 2020. The bill before us provides for the registration and regulation of real estate agents and other related matters. The main objectives of the bill are: 1, to promote transparency, accountability, and integrity in the real estate profession. 2, protect and assist persons engaged in real estate transactions with real estate agents. 3, assist in the detection and prevention of money laundering and terrorist financing and other related matters. An industry which accounts for approximately 2% of gross GDP can be construed as significant to the economy. In Trinidad and Tobago, the real estate industry is an integral part of business activity, and transactions on average represent $3 billion, or 2% of gross GDP. The world financial crisis of 2007-2008 had its genesis partly in real estate transactions through mortgage financing, or what is called securitization. Securitization is the financial practice of pooling various types of contractual debt, such as residential mortgages, commercial mortgages, etc. We all know how that ended, and not all countries have recovered fully from this global economic tragedy, as still is the case with our economy. The UN Global Compact, using the principles of human rights, labor rights, and environmental protection and anti-corruption, discovered that throughout the world, the real estate industry is one of the sectors that least adheres to sustainability and best practices. Mr. Vice President, at the present time, any legislation governing the buying and selling of real estate in Trinidad and Tobago is woefully inadequate. While regulations exist for architects, attorneys, engineers, surveyors, and urban planners, the sector comprising real estate agents is the only sector in the property sector that is unregulated. The Association of Real Estate Agents area, established in the early 1990s, is a self-regulating body that has developed standards and agreed operating rules for participating members. The organization's disciplinary committee may enforce penalties for infringement by members as set out in its articles and regulations. However, area is constrained in that it cannot deal with matters extraneous to the association or that do not involve its members. Also, they have no powers to mandate persons and companies operating in the real estate market to join the association or abide by its regulations. Given the lack of adequate legislation and an impotent governing body, it is evident that the industry should be structurally formalized so as to adequately, 1, protect buyers and sellers, that is, prevent rogue operators preying on the unsuspected person or company, 2, prevent and detect money laundering, 3, implement a code of ethics, 4, formulate standards for operations, 5, develop licensing requirements, 6, provide definition and guidelines for the roles of the various players, 7, agree enforceable disciplinary measures. Mr. Vice President, there needs to be a clearly articulated transitionary plan during the period when these legislative changes are being implemented. The appointment of suitable persons to the licensing and disciplinary committees will take time. The application and approval process of members will also be a time-consuming exercise. The board of the Real Estate Association can only be constituted when a significant part of the registration process has been completed. Only then can the board members be elected and installed. I think the roles and responsibilities of the various committees and organizations defined under the bill should not be left in abeyance while the registration process takes place. I suggest that the bill include a holdover requirement for the current board of the Association of Real Estate Agents to have a reasonable transition time until elections can properly be held. This will allow for the smooth transition to the operationalizing the legislation. Registration of real estate agents, clause 18 and 19. Registration of real estate agents should be a one-time requirement. Re-registration every 3 years is a burdensome process when coupled with the renewal of the real estate agent's license. The real estate agent's license can be renewed annually. The real estate agent must yearly meet the requirements for license renewal as stated in the Real Estate Association's rules and regulations. Licensing Committee, clause 30. It is standard practice that professional organizations are required to include members of their profession on the Licensing Admissions Committee. These persons are most suited to assess applications for admission into their profession. This should also be applied to the Real Estate Licensing Committee. Disciplinary Committee, clause 54. In the bill, the committee is to be comprised of 7 persons appointed by the President, a chairman who's an attorney at law, 3 attorneys at law, and 3 persons with 5 years' experience in the real estate business. The bill defines a requirement for persons who engage in the real estate business. Therefore, representatives from the real estate sector should not merely be persons with experience in real estate business. The 3 persons selected to represent the real estate industry should be licensed real estate practitioners with at least 7 to 10 years relevant experience. These persons must be fully au courant with real estate practices, procedures, and all applicable legislation. In matters concerning disciplinary decision of administrative bodies of professional organizations, such as the Disciplinary Committee of the Real Estate Agents Association, standards of conduct intrinsic to each profession are best known to and assessed by the specialist bodies governing that profession. I recommend that this principle be applied to the persons representing the real estate industry. Real estate sales associates. In the bill, clause 42 states that a sales associate could apply to the licensing committee for a license if he intends to engage in the business of a broker. The bill does not make it mandatory for a sales associate to be licensed. The bill also limits the role of the sales associate in dealing with clients' monies. It is current practice that sales associates are in the field meeting with clients. They generally negotiate the terms of the property sale, purchase, and lease. The sales associate also physically receives the deposit check or draft from the client for deposit into the broker's or attorney at law's escrow account or hand it over to the vendor or landlord. Prevention of this practice will create an unnecessary administrative challenge, which is not in keeping with the standards of practice of the real estate industry. Real estate sales associates must be licensed. Their function should clearly state that they act under the supervision of a real estate broker. Also, the real estate sales associate must be linked to a broker or brokerage company, and the broker has a duty to supervise the sales associate. Rules, Clause 79. Clause 79 states that the Registrar General may, with the approval of the Minister, make rules, prescribe forms, fees, and other matters relating to the registration under this Act. In this regard, I recommend a participatory approach. The Registrar General should collaborate with and seek the recommendation and possible agreement of the Real Estate Agents Association. Mr. Vice President, Clause 15 of Schedule 1 prohibits the payment of any compensation to board members of the Real Estate Agents Association. However, Clause 33.2 and Clause 57.2, members of the licensing and disciplinary committees are also entitled to compensation. The role of the board, as defined in Clause 24, includes improving standards of conduct and proficiency of real estate agents, promoting compliance to the Code of Ethics, representing, advancing, and protecting the interests of real estate agents, developing initiatives for the efficiency and effective delivery of real estate services, protecting and assisting the public in all matters relating to real estate business. Mr. Vice President, given this array of responsibilities and considerable investment of personal time required by board members, I am puzzled as to why some form of monetary compensation is being withheld from board members. Thank you, Mr. Vice President.
Minister of Trade and Industry.
Thank you very much. Thank you very much, Mr. Vice President. Today I'm very pleased to be part of the presentation of this bill. Again, I want to thank the AG, the Attorney General, for bringing this forward. It's long overdue, but I give him all the credit because when we first came into office, I remember meeting a couple of people from area, and it's the AG who really took up this cause with them and pushed the work through to ensure that it was brought before the end of the term. So I'm very pleased about this. They've been around a long time. But in the truest sense, whilst they have been a formal body, today we are going further and regulating the industry. And there are several reasons why I'm pleased that this bill is here. And it's a really very well-constructed bill, contrary to what Senator Mark is promoting. One, because this industry, this real estate industry, is a very valuable industry in the economy in terms of its contribution to GDP, employment, and possible exports, and so that it's a feature of trade. And two, because it seeks to deal with criminal matters, and AG spoke about that, like money laundering and so on, because it's well known that dirty money finds its way in real estate purchasing. And three, this bill protects consumers, those who are involved in the purchase and the leasing of property. So if I go straight to the point about the value of the industry, according to the 2019 annual economic survey from the central bank, this real estate industry was responsible for 2% of GDP between 2015 and 2018, and 2.1% from January to March 2019. And I compare to agriculture, which is just about 1%. And in 2019, looking at the review of the economy, the contribution to GDP was something like $3 billion. So the real estate sector saw some growth, 2.4% growth in real economic activity in 2019, and we're very pleased about that. I looked for the employment figures, and but the only thing is the central bank combines the finance, insurance, and real estate services sector together, so that there were some 4,600 jobs recorded in terms of an increase in employment. But however, it's difficult to segment, but I do know that there are considerable number of persons involved in the industry. COVID has affected them too, so that they're under a bit of pressure, and especially liquidity pressure as well. But of course, this trend will be reversed when the economy enters its recovery phase. So I'm not going to speak about area again. I think several speakers spoke about area and what they do. But again, I wanted to speak very broadly about this services sector. And because of the importance to GDP, again, as I said, is they make the largest contribution to GDP ahead of manufacturing, ahead of energy as well. And that's why it's so very important. The only thing is it includes, again, as I said, several other areas, ICTs and business and so on, business services and so on. But again, the importance is a very real one when we speak about diversification. That now that this has become formalized and legislated, it's one that can be, that is an area, it's a small industry that is important to diversification, along with the rest of the services sector. I don't have the trade data, but I can tell you that, that there are local companies. Terra is one of them, Terra Caribbean. They are known to have operations in the region. I think they might be in Grenada and Barbados and St. Lucia. So already they are contributing to exports. I don't have the export figure. I don't have, what I do have is the export figure for business services, and they're included in that. And that would have been a figure of about, in 2018, about $43.6 million US. Unfortunately, when we look at business services, the imports were a lot larger. So there's a terrible imbalance there to be fixed, and real estate can contribute to this. And clearly, this is an area for growth now that the sector is regulated. Even from the perspective of trade, I looked at our new trade policy, which is the policy which will take us into 2023. The policy does not have real estate services as one of the key services industry for development of exports. Tourism is the education, health and wellness, financial and professional services, and so on. But again, I want to see it's valuable, and it confines itself as an industry contributing to the development of the services industry and for the exports of services. And again, even at the level of CARICOM, and I'm going to go quickly from this point, There is a regional strategy for the development of services as well, the CARICOM Regional Services Strategy. And again, it doesn't speak to directly the real estate services industry. It speaks to a professional services strategy. And in that strategy, it creates an opportunity to register, to have one regional single registration initiative, together with draft model legislation. Again, the industry is not covered by the legislation, but I see them being included under the professional services strategy. So I think that there's every opportunity to raise the competitiveness of the industry, and so that our real estate professionals can in fact benefit and grow. I spoke about the second very important aspect of this bill, and that is because, and AG spoke about it fleetingly as well, that there is money laundering involved in real estate, and that's a very real issue because criminals just absolutely love real estate. And you can find, even in Trinidad and Tobago, there are many of those who engage in money laundering, and they would buy properties in Bayside and the Summit and in the Renaissance and so on. And they must be stopped, because really when they reside there, and many times they just leave the property empty and come on occasion, moving from one property to the other. But they're really disrupting the peaceful and safe lives that those residents are enjoying after they've made their considerable investment. So, in many instances, there are ill-gained financial ill-gain proceeds caught up in the purchase of buying real estate, and this is definitely linked to crime. As I said, in Trinidad, but all over the world as well, in Manhattan, in Knightsbridge, in London, and so on, in Vancouver, in Canada, and so on. It's a real problem. And AG spoke about the large number of suspicious transactions globally. My understanding when I did my research, and I got this from Acuity, which is a global risk company, there's something like US $1.6 trillion a year. US $1.6 trillion a year in terms of ill-gotten proceeds wrapped up in real estate and so on. And usually they do that by using a shell company. And it's something that countries have to deal with, and I'm happy to hear that we are dealing with it. But this is not the only occasion when this government has dealt with this aspect. Again, AG also introduced the Explain Your Wealth Bill in 2019, the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019, which some people thought was quite a draconian bill and so on, but we know why. But again, all of these opportunities by this government to deal with money laundering and ill-gotten wealth and so on. So many countries are being progressive, and Trinidad and Tobago here is being progressive by introducing this piece of legislation and ensuring that this whole aspect of dirty money being involved in real estate is in the past. The other reason why I was so pleased with this bill is because it favors the consumer. And I say so because of the very construct of the bill. In Clause 5, for instance, what is spoken to is the exception of who is not regarded as engaging in real estate business. So in a sense, we are protecting the purchasers of property here and those seeking leases. For instance, if you're given legal advice, you are not engaging in the real estate business. And of course, if you're acting under a power of attorney, if you are a developer, and we went through some of these, if the person is employed by a financial institution, in other words, if you're a bank and you're dealing with property transactions and so on, you are not regarded as engaging in real estate business. So I like the fact that the Clause 5 speaks to the exceptions. And then again in Clause 10, Clause 10 addresses the disqualification of an agent and gives the grounds for such. For instance, if you're involved in fraud, or so if you were convicted of particular offenses, etc., you will be disqualified. And then, of course, the public also has the opportunity to object to an applicant's registration. And that's another area of protection. The bill also very generally deals with professional misconduct, and this is by virtue of Clause 47. The bill is distinctly clear in defining what constitutes professional misconduct by a real estate agent. Things such as dishonesty, incompetence, impropriety, negligence, identity theft, poor documentation and records of transactions, knowingly making false or misleading statements and committing fraud, lying by omission, acting as a dual agent without informing the client, issues, breaches of the Code of Ethics, and so on. And Senator Mark raised the issue of the bill not including a provision for a Code of Ethics, and that's not so, and that tells us that he really didn't read the bill, and I'll come to that. And of course, the bill also provides for disciplinary proceedings. So, and the setting up of the disciplinary committee under Clause 54, Part 9 of the bill. As I said, Senator Mark made a big brouhaha also about the fact that that area had been left out. But really, the bill provides for a governing body called a Real Estate Agents Association under Part 4 from Clause 21 onwards. And because he said that real estate agents would be left out, but this is far from the truth, because the association, the Real Estate Agents Association, allows for a maximum of 10 members, but the legislation only provides for 4 specific members. That is the president, the vice president, the treasurer, and the secretary. And in any event, they only speak to, the legislation only speaks to specific requirements for 4 members, and remembering that you in fact allowed 10. And 2 of those 4 members are persons involved in the business of real estate. It only provides for 2 other real estate, for 2 other non-real estate persons, and that is someone with experience in finance, and also an attorney at law with 5 years standing. But other than that, there's room for 6 additional persons, and those 6 persons could, in fact, be all agents. And the bill having provided for 2 persons with real estate experience, the bill actually, in that governance body, in that governance arrangement, actually allows for at least, perhaps up to 8 persons being real estate agents. So I think Senator Mark's concerns are really ill-founded, and as I said, this bill is well constructed and really provides for the participation by existing members of the real estate of area who may wish to be part of this governing body. And Senator Mark also raised this issue about, yes, the Code of Ethics.
Minister, you have 5 more minutes.
Yes, Senator Mark also raised this issue about the Code of Ethics. And Clause 80, as I said, if he had read the bill to the end, Clause 80 provides for the establishment of the Code of Ethics of real estate agents. And this is by order of the minister or under recommendation of the Real Estate Agents Licenses Committee. And I looked at the standards of standard of ethics by the National Association of Realtors in the U.S. And I'm very pleased with what it provides for in terms of it gives general standards of practice, including duties to clients and customers, duties to the public, duties to realtors as well. It really makes for honesty and integrity and confidentiality and accountability within the business within the business of realtors and how they organize themselves. So I have to close, Madam President, but do we need them? Let me answer that question. Yes, we absolutely need these real estate agents. So what we're doing here is a tremendous service to, as I said, legislating and formalizing them. They are the ones who work very hard and help us when we are purchasing or leasing properties. They understand the business and how to get it done. They are the ones who help you to get to know the client. They know to understand your criteria. They do the matching. They are involved in negotiating. They are familiar with the business of contracts and the conditions therein. As I said, they protect you. They protect consumers. And again, when in fact the code of ethics is set up, this will certainly add to ensuring that this business is one that fits well with what this bill intended to do, which is to ensure that there's honesty and there's integrity, as I said, confidentiality, accountability in the business of real estate. Thank you, Madam President.
To join this debate on an act to provide for the registration and regulation of real estate agents in order to promote transparency, accountability, and integrity in the real estate profession, amongst other things, Madam President. And Madam President, this particular piece of legislation comes at a time where we are probably only a few weeks again until the official close of this Parliament, this 5th session of the 11th Parliament. And we have seen that the Attorney General in this pandemic has continued to push particular pieces of legislation through this Parliament for whatever reason. And this one, I have seen some level of rationale or reasonableness in bringing this legislation. Simply to say, Madam President, is that recently, if you remember, the Attorney General traveled to Paris, where, when he went there, Trinidad and Tobago was assessed in terms of a mutual evaluation by FATF. And this Parliament, in particular this Senate, has engaged in over 4 years of passing laws to treat with money laundering and counter finance terrorism. And this particular bill that we are passing, Madam President, falls within that landscape, or it is contemplated by FATF that we need to regulate our real estate industry in Trinidad and Tobago. This comes in the background, Madam President, because in this industry that deals with land, fraud is very common. It is not something that is foreign to these transactions. And I have some statistics, Madam President, that I got from the Law Association through a seminar entitled Fraud and Identity Theft in Conveyancing Transactions and Certificate of Title to Property. And Madam President, it shows that in 4 years, we're looking at 2014, 2015, 2016, and 2017, the number of reports have increased. From the year 2014, there were 45 reports of fraud amounting to $16 million. And in 2017, 75 reports of fraud amounting to $17 million. In 2014, Madam President, you would know that there were 20 deeds that were expunged from the registry as a result of fraud. In 2015, 30. In 2016, 27. In 2017, 51 deeds. What this shows, Madam President, is that the 51 persons whose deeds probably were expunged in the year 2017 meant that they lost their property. And in Trinidad and Tobago, land is something that is very valuable. That is not something very small, Madam President. These are life investments that persons make. Persons save for their entire lives, they work for their entire lives, they pay mortgages just to own a property in which to live on. And then, Madam President, you have certain persons in society that will take advantage of a situation and rip off these persons of their life investment through fraudulent transactions. So we are saying on this side that yes, we welcome the industry to regularize fraud in terms of the real estate agent to prevent fraud from occurring. Madam President, in this particular piece of legislation, this deals specifically with only real estate agents and developers. And when you see what the legislative intent of this particular bill is, it is really to create a registry and a registration system and a licensing system whereby sale associates, brokers, and developers will now be falling under certain registries that are maintained by the Office of the Registrar General. The second thing that the bill does is establish the association. The third thing is establishes a disciplinary committee. And then the fourth thing, it establishes the licensing committee. And I want to make some points in terms of the composition of these committees. Madam President, when you look at the association, for example, you would see that the association would be made up of registered members of the industry. Members who are now required to register and license under this particular legislation in order to practice the real estate business. And you would see that there were 4 persons or 4 office holders that will comprise the association. It is the president, the vice president, the treasurer, and the secretary. That is found at clause 22 of the bill, Madam President, part 4, Real Estate Agents Association. And obviously these persons will have to be elected by its membership. But you must remember, Madam President, that this bill has a transitionary period of about 12 or 16 months. So what is going to happen in that time of the transition period? Because now you will have persons who will have to be approved by the Registrar General in order to practice. So, Madam President, we are asking on this side that we have an association in Trinidad and Tobago that is well established, incorporated under an Act of Parliament, Act 10 of 2012, the Association of Real Estate Agents, allow them a part to play in the transitionary role from this system into the new system, Madam President. The Attorney General boasted about the yeoman service that this particular group has done for Trinidad and Tobago will allow them to be a part of this transition period to make it more smooth. We all know what is happening at the Registrar General's office, Madam President. Without anticipating, there's another bill on the order paper that will increase the burden of the Registrar General's office. And in this particular bill, you are now increasing the burden even more because you are asking for a register to be maintained by the Registrar General for sale associates, for brokers, Madam President. And we all know what happens at that office in terms of resources and understaffing. So allow an association who has the expertise, who has the experience, who has the competency, Madam President, to be a part of this process. This particular piece of legislation has completely isolated area from the business of real estate. It has now taken a position, the government that is, has taken a position where they have placed their executive hands in terms of the control, the regularization, and the supervision of this particular industry. And we are asking, Madam President, that there must be some more inclusion of the membership. So that is the association I dealt with in terms of representation by area. I want to move on to the licensing committee, Madam President. And just for those who may be listening to us on television or on radio, under the new system, a person has to be registered under the Act to practice, and then they must get a license in order to practice. Now, the licensing committee will deal with the licenses, Madam President. But this is the membership of the licensing committee. It deals with that the president, meaning that is the cabinet, shall appoint the committee comprising 7 members as follows. A chairman, who is an attorney at law, 10 years experience, on the advice of the JLSC. A deputy chairman, being an attorney at law, 10 years standing, on the advice of the JLSC. An attorney at law, 7 years standing on the advice of the JLSC. A person with experience in accounting, business or finance nominated by the minister, and that will be the minister in charge of legal affairs. And then you have 2 persons, only 2, Madam President, who have 5 years experience in real estate business. Nominated by who? The minister. Then you have 1 representative from the THA. Now the problem I have with this composition, Madam President, is that you are bringing foreign persons to now rule on licenses. The majority of the members who sit on the licensing committee may not have any experience when it comes to real estate, but you only have 2 members of that committee who has experience in the real estate business, but it's not coming from area. It's not coming from any other real estate agency or body. It is coming from the minister. Why is the government trying to keep their executive hands placed onto this industry? Why don't you give the persons with the competency, the experience, Madam President, an opportunity? Why it is that persons who have to serve on this licensing committee should not be nominated by the body that is recognized as the real estate agency? Then you have the other body, which is the disciplinary committee, which is found at clause 54 of the bill. And at clause 54 of the bill, this is part 9 of the bill, Madam President, it establishes a disciplinary committee which comprises of 7 members. 7 members, again, appointed by the president. And it goes like this. It's the chairman on the advice of the JLSC. 3 attorneys at law, 7 years standing, appointed on the advice of the JLSC. So that is 4 members. Then again, 2 persons with at least 5 years experience in the real estate business and 1 broker with at least 5 years experience. So again, you have 4 members who are not experienced in real estate and just 3 who are experienced in real estate. Now, the problem I have with this is that these persons will now be performing a quasi-judicial function. They will determine whether or not a broker, they will be determining whether a sales associate, they will be determining whether or not a developer would have met the required threshold to see whether or not they can be disciplined. Now, who is best to determine whether or not a person reaches the professional conduct and standard of a business or a particular industry? It is persons who belong to that industry. Just like the law association, if you fall below a certain threshold of conduct, Madam President, you know we can fall afoul or breach the code of ethics, which can result in liability, in the attorney at law incurring liability. Now, in this case, you have foreign persons who are judging the conduct and the standards of real estate businesses. Why, again, Madam President, and I'm calling, allow persons in the industry to nominate, to appoint, to advise the cabinet in making these appointments, Madam President. Allow them to do so. And what is strange is that you would see that all the attorneys at law who are going to be appointed to sit on these committees are going to be appointed on the advice of the JLSC. Which means that I would ask the Attorney General to clarify this. It is whether or not Cabinet can disagree with the option of who the JLSC would have nominated. Because if you had inserted the words in accordance with the advice, it means that it's a mandatory appointment. There's a next terminology that is found in the Constitution in consultation, with the advice of the JLSC. So I want to ask the Attorney General, if Cabinet does not, or is not satisfied with the nominees that are placed by the JLSC, whether or not they can differ with what appointments or persons nominated by the JLSC has placed on them. And again, what this shows, again, it is executive overdrive. It is the executive keeping their hand on this particular industry. And we have, Madam President, to ensure that this doesn't happen. We have to ensure that this association, this industry is allowed some level of breathing room. Because I looked at different jurisdictions. I looked at the Bahamas, Madam President, for example. In the Bahamas, when you look at the legislation there, you would see, for example, and I'm quoting from the Bahamas Real Estate Brokers and Salesmen Act. And at section 25 of that act, Madam President, there is something called the Investigation Committee and the Disciplinary Committee. And you would see, Madam President, that that committee is made up of a chairman who will be a member of the board, similar to us, and not more than 7 other members, 3 whom are appointed by the board, which is similar to our association, and 4 of whom shall be appointed by the minister from amongst persons who are not members of the association. And when it goes on, Madam President, you will see that it allows some level of inclusion of the BREA, which is akin to our AREA in Trinidad and Tobago. In New Zealand, you see the same thing. Now, I heard that the Minister of Trade and Industry, and normally I'm very impressed with the Minister's contribution, but today I was very disappointed. And I say this, Madam President, because it seems as though the Minister didn't read the bill before she came to the Senate. It seems as though that the Minister did not properly analyze the clauses of this bill. It seems as though she read from a prepared speech. And I say this, Madam President, because the Minister said that we're making a brouhaha about area being left out. Well, yes, they are left out, and we have a right on this side to advocate
Senator
about
Hussain,
that. Madam President, when you look...
Senator Hussain, you have 5 more minutes.
Thank you very much. When you look at the appointments, why it is that most of these appointments are not being made with the consultation of the association? Then the Minister went on to say that this will favor consumers. Madam President, I would have you know that in order to now practice real estate in this country, this is what will happen. These agents will be required to pay a licensing fee. They will be required to register. And now it's mandatory that they have professional indemnity insurance. What does that mean, Madam President? It means that the sale, the cost of land transactions in Trinidad and Tobago will increase. It will increase. So when the Minister says that this bill is favoring consumers, I don't know which consumer they're favoring. But it is certainly not the ordinary citizen in Trinidad and Tobago who uses their entire life savings in order to make an investment in land to build a house for themselves and their families. There's one other very small part of this bill I would like to touch, Madam President, and that deals with the definition of dual agency. Now, dual agency, according to the bill, will now be an agent will be facing disciplinary action for that unless they disclose to the vendor and the purchaser that they are acting for the both. Now, in England, I believe it was abolished, but there are some jurisdictions that maintain it. And the current definition that is found in the bill, Madam President, that deals with dual agency, it is very silent. The definition is silent on whether or not the persons have to be monetarily compensated. It all talks about representation of both parties, but excludes any issue that comes about monetary remuneration, Madam President. And this is something I would ask the Attorney General at the committee stage, which we can look at in terms of tightening up the definition, because there will be a lot of agents who can, in fact, fall afoul of this particular provision and face disciplinary action if they act as a dual agent. So, Madam President, while on this side we say that we agree with the regularization of the industry, we also ask that persons in the industry not be left out and they are part of the process. That is what a democracy is, Madam President. And I thank you very much.
Thank you, Madam President, for allowing me to partake in this bill. Madam President, first I might say that the bill seeks to do 3 things, actually. To regulate the real estate profession, which is, and they need to be regulated, to protect the public, to protect the public and assist persons engaged in land transactions, and also to assist in preventing and detecting money laundering and terrorist activity. So 3 main importance. 1, looking at the real estate agent, then the protection of the public, and also the fit in with the FIU regulations. And it is needed. And I say, yes, this is quite needed. And even, I want to quote, Madam, Thursday, 16th of May, 2019, a Newsday article, Criminals Using Real Estate for Money Laundering by Siobhan. And actually, a police officer gave the whole idea that the criminal elements are abusing the real estate industry to hide their money. And even an article in Forbes, November 21st, 2018, Vishal Maria warned that foreign criminals were using UK property markets to launder dirty money. The lack of regulations made real estate market a refuge for criminals to clean funds, to avoid taxes. And in this article, they said that this causes a great impact on the property market, because then the average prices of homes people couldn't afford because they were being bought out from foreigners. They were being bought out by these drug lords. And again, this would have had a social impact on the ordinary man to really afford property. So that social impact, I'm thinking, we have to look at if we can help this with this piece of legislation. Also, they mentioned developers are now prioritizing more profitable high-end luxury homes that are popular with foreign investors. So the social impact is there. We have to ensure that the money is not put into property that will elevate their prices, and the small man now will be at a disadvantage. So the affordability of persons to live in property is something that we have to look at as much as we can help these persons. Now, at that article, they mentioned also that when they looked at the fact that properties are being bought out and sometimes unoccupied, and then you have what they call ghost communities that came in, because if you develop a land and the owners are brought by this, there's no infrastructure, nothing going on there, nobody maintaining. It loses that little ecosystem where you have workers working in that property. So the economy itself is not stimulated. And it did mention the fact that suspicious activities, when they looked at suspicious activity, somehow the real estate agent did not report a lot of the infractions that occurred. The independent legal persons gave, accountants gave, but there was a minuscule reporting. So therefore, the legislation to oversee, to look at these companies, to identify, I think it's something that we need to look at. And what I'm saying, Madam President, we may have to look at the fact that if an overseas company comes in here to buy property, we may have to let them not hide behind companies, may have to declare their owners that could be visible for foreign policing services also. So we actually will have to look into that. And in the United Kingdom story, they first successfully targeted a house worth £11.5 million in West London, purchased by a company from British Virgin Islands, and Zamina Hajiva, a wife of an IBA banker, was convicted of embezzlement because she couldn't explain her funds. And this is what the Attorney General has been trying to say. We have to go after. It's a dream peddled by him. But you see, this brings up other things that I would like to see here. Because remember, Tobago, foreigners come and buy land. We have to look at if those foreigners who buy land, it's a new way of colonizers coming into the Caribbean, owning property, increasing their wealth, denying national prices. So it's really, it's like capitalistic foreigners invading our country, and capitalistic malefactors or bandits. And we have to look at these foreigners coming in and guard it. Look at the real estate money coming in and being hidden in our economy. And the thing is, the Attorney General did mention $23 billion of suspected activities. It's a lot. And I mean, his hands are not ready to go dipping and finding these personnel. But, Madam President, the majority of realtors I know are honest people, people who probably retired teachers, retired individuals from public service who went into this to make their money. Housewives, they go in. So most of them I know have honest vein in them. However, the figures show startling results. Something is going on, something we need to look at. And you see, the thing is, I remember once when I was in the United Kingdom, and I opened a magazine and I saw a glossy advertisement for land for sale in Tobago. So therefore, you have to appreciate that these realtors could have far-reaching consequences where they could advertise the country for sale. And the Adrian said the land is our national asset. So therefore, we have to look at and be cautious of these things happening. Post-COVID, Madam President, I fear that what may happen is certain real estate agents will not be able to make it. It's a fact, because people wouldn't be able to buy land. So I fear for them. I also fear, too, that certain cliques may come in the real estate agencies, certain corporate-run estate entities could rule the market, and some other small agents may be forced out. So a few of them remaining may be like crabs in a barrel and may try to somehow bend the rules. So we have to appreciate, we have to have rules and regulations. This piece of legislation, Madam President, I was disappointed when I saw that the clause 3, that the developers, were basically left out. The developers are the ones who target the foreigners, who try to bring them in. And you see, what I'm saying there, for maximum transparency and to actually reach at some of those people who may be using this real estate to hide money, I'm thinking the developers should have been there, or I'm hoping some other legislation comes into place that would satisfy this. So we know that, Madam President, that people tend to hide behind companies, people named in may never see, and this is what I'm saying, the transparency in who owns land, who owns company has to be above the table, has to be something. And I remember there were instances in the US a few years ago when they approached Trinidad and Tobago to see which of their nationals had bank accounts in Trinidad. And I think it was some sort of arrangement they tried to make. So again, naming these individuals who come to buy properties here would also assist the the United States in their fight to stop this. We all remember, Madam President, I hesitate, but I have to raise the ghost of Johnny O'Halloran and Francis Privat. We have to remember in the song immortalized Panama by David Rudder, he mentioned about the money that left here. He said 1,000, some say 10,000, some say 1 billion, and he spoke about the land. And, people realize lands were bought in Panama, lands were bought malls were bought in Canada. So we have to see people who actually occupy these hollow chambers actually partook in this same thing we are trying to avoid here. And I commend the Prime Minister of bringing this up. Even I have to bring mention to the fact that a carpetbagger, as he was described by Prime Minister Keith Rowley, Cola Hart was described as a carpetbagger, and again immortalized in a song by Horace Liverpool, where he spoke about corruption. And there were instances where we had listing from the Off Commissions about properties owned, five apartments in Woodbrook, one on these places, and other places, Goodwood Park list. Madam President, we have to get at the root of this. We have to get the corruption out. We have to show the younger persons that Parliament is serious in passing legislation where corrupt politicians should be held accountable. Because a corrupt politician is in a degree of trust. And you find that young people looking out there would want to see and want to hope the country could get better. And even in China, if you have a corrupt public official, they have that penalty. Here we should probably have some mandatory life sentence without any sort of bracelet for any public officer, any minister that is involved in any sort of transaction that brings the country, brings the taxpayer into somehow the taxpayer dollar going into corruption, which denies persons medical care, decent living, poverty eradication. So, Madam President, I must say, there is, in the USA, there's a former President Trump campaign chairman, Paul Manafort. He was charged for money laundering through real estate. He renovated and sold properties, 18 million US. And he was a man who was in lobbying. Real estate purchases amounted to 6.4 million. And you see, this shows that the hands of corruption goes right through. And very important, he was a campaign manager. So campaign finance reform, I think, should be something, I think, in our agenda. Now, I want to make mention to the fact that there appears to be strained relationships between the United States and Trinidad and Tobago. And I must say, there was an article where, and I'd like to quote, United States worried over lack of money laundering convictions in Trinidad and Tobago, and it was in Pride News, April 10, 2018. And they said despite bringing in cash seizures and forfeiture cases to court, there have not been many laundering convictions. They did praise, though, that, that we have a stable, relatively stable economy. We have a good development financial system, but the close proximity to drug-producing countries makes us a target for criminals, a more target within the whole Caribbean. This is why we have to show as a nation we have laws there to help. And they said even though there were 13 financial prosecutions, there was no conviction to date. And the lack of the AMC supervision or giving them more teeth was one of their reasons they give. Madam President, Part 7, Clause 47, would definitely assist this part where you have fraudulent real estate agents on the prowl. There are good ones, there are bad ones. And there was a situation where recently 68 persons bought lands in Cedros. I think and out of that, 7 million were paid. They needed, and they went to a real estate agent, and they were all tricked. So when you see things like that happening in Trinidad and Tobago, you see, yes, there is definitely a need to have real estate agents under some sort of a guideline, some code of ethics, some level of having these real estate agents, looked at. And Madam President, I would like to say I heard a lot of praises made to the area real estate agency, which I think came about. I think that group was incorporated as an act of parliament, I think, when Mr. Boutirari was a minister, and I think he got back in from our present AG then. And they did good jobs. They brought code of ethics. They brought education. They actually tell people how to run things. But, their membership is not much. When you have about 700 persons who are real estate, 7,800, only 78 resident brokers, 112 sales associates, and 17 corporate members are members of area. And I asked a member, why are you not joining this group? And, this lady from Rio Claro, who is a real estate agent, she said, Doc, all I do is sell a little land, get a little money. And, persons in Port of Spain, that's a sort of she described it in a way that it's like elites, a plantocracy elites of persons in area. So not everybody would be thinking they are welcome to area. Now, my problem is this. If we are now going to have this real estate agent...
You have 5 more minutes.
So, thank you, Madam. If we are now going to have this real estate association brought to fact, I'm thinking, yes, area members could join, but we have to encourage the small man, we have to encourage the small real estate agent to feel welcome enough to join this association that is now going to be put in law. You see, so the real estate association has to be welcoming to the interests of all these agents. And Madam, when you are now changing this law, and you are now asking membership to come and vote for president and vice president, remember, first you have to register these people. And these people, according to one of these stipulations, they have to be 18 years, and they have to be some sort of exams they have to get also. I am thinking in this period of transition, we have to have some way of factoring those persons who are real estate agents for years, grandfather them in, let them come in as real estate agents. They wouldn't have exam, they mightn't be able to do exam. Factor them in, give a period, a sunset clause where after a year you have to get your exam, but factor these individuals in who can now combine with the area personnel who probably did little exam in their courses, and you get your membership, and then we can move forward. I have mentioned already, Madam President, that I was disappointed in the fact that the developers were not factored in. I also have a little concern that state agencies were not factored in because, Madam President, the state deals with property. Fidelis, Federation Park Properties. We have seen in the past, I think just recently, Mr. Rambarat had to deal with grand larceny of state lands where people working under his department, senior officers, were involved in a land deal. We had cases where I remember people questioned the Jamat land deal in Mukarapo. Then you remember in 2000, I think 2004, our Minister of Public Utilities were questioned about Wassa houses being sold to Wassa Management. Recently in Greenvale, people were occupying houses and they didn't have their permission. So we have to be more transparent also, not what's going on in the real estate agency out there and transaction, but transactions that occur within the ambit, of what pertains in the state. So those are things I think needed to put in, or if it will come in further legislation, I welcome it. I want to say that the obligation to put developers to register in a prescribed form of registration, Clause 6, commendable, because we need to know who are the developers, because remember, they may be involved in doing some activity. Madam President, Senator Marks said this is a convoluted piece of legislation. I have to agree with him, because I'm seeing you're given an association, TEAT, then you're given an association, you're also looking at a licensing committee, and also the licensing committee and the disciplinary committee. Madam President, in the medical association, we have members there who are doctors, but the IRO has a member, the ICLAT has a membership, the law association puts a member. To give a balance, so it's not just doctors who are controlling doctors and not disciplining doctors. So I'm suggesting instead of having 3 different entities, have one entity, but factor in that entity, yes, the people who are voted in, but you also factor in a member from the IRO, a member from Transparency International, a member, even if they joins the JLSC wants to put a member, put them in. So you have the National Land Tenants Association. So you balance the real estate agents with these individuals. So the real estate agents couldn't form cliques, be a law unto themselves, and they can still have the quasi-judicial function that we have in the law in the medical association. They could still form that function and at least be able to discipline members and be able to function in that way instead of having disciplinary and licensing committees. So this is where I look at this. I was a little concerned about the mandatory joining, if that would breach the Constitution. And also, I also look at the fact that I made mention of the fact that the factoring of the other real estate agents who have been in business for years needed to be looked at. It's unfair to tell people you're a real estate agent that one day doing business, and then all of a sudden, no, because of some regulation, you stop that. Factor in for a year, start afresh after. And I think when we do this, we will be able to have more professionalism in this area that is needed. We will be able to protect the individuals out there from unscrupulous real estate agents, and we will also be able to look at the developers later on and look at other entities that was not really included. I thank you, Madam President.
Senator Sobers.
Madam President, thank you for recognizing me this afternoon to make my contribution on an act to provide for the registration and regulation of real estate agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions. And as the bill entitled goes on further. When I looked at the bill, Madam President, what definitely caught my eye was the aspect of the prevention of money laundering and terrorist financing and other related matters. And I can indicate that being a practicing attorney at law myself, I have been involved in matters where I actually saw elements of these types of activities being manifested in this particular area of conveyancing that apparently has been going on for quite some time without proper regulation. And I will get into that a bit later on, because I think many persons who are aware that we are actually having a discussion, a debate on regularizing or putting a framework in place for the regularization of real estate agents don't really understand the dangers of actions related to that particular profession being unregulated. The corrupt practices that take place in some instances, the loss, as Senator Hussein would have indicated, to many persons who would have worked extremely hard to procure property over a particular period of time. And fraud in real estate transactions and anti-money laundering and counter-financing of terrorism is a very real concern that the opposition definitely has with respect to an unregulated profession such as this. And Senator Hussein would have touched on the fact that as recently as in 2017, the Law Association in a public presentation in 2017 themed an identity theft in conveyancing transactions and certificate of title into property, noted that there had been a general increase in the number of cases of fraud involving transactions with real property between 2014 to 2017. They went on to indicate that in many cases, fraudsters utilize the services of an unsuspecting or even complicit real estate agent to procure these fraudulent transactions without any legislation at that juncture to regulate the activities of real estate agents and without any obligation for them to be FIU compliant. An innocent purchaser may be unable to determine the bona fide of the real estate agent for the particular transaction. This legislation is necessary to assist in reducing the prevalence of fraudulent misrepresentation in real estate transactions. While fraudulent misrepresentation can be prosecuted as a criminal offense with sentences of imprisonment imposed, this may not necessarily result in the recovery of sums paid in a transaction. The number of cases of such fraud reported by the TTPS, as Senator Hussein indicated, rose exponentially between the periods of 2014 to 2017. Also, in its AML CFT guidance for the real estate sector, the FIU of Trinidad and Tobago also stated, it entitles operating within the real estate sector operating within the real estate sector are subject to POCA and the Anti-Terrorism Act. However, further obligations are imposed on those business activities which face a greater risk coming across crime proceeds and terrorist property. They went on to indicate as well, too, that various reports produced by the Financial Action Task Force over the last few years have made reference to the fact that the real estate sector may be one of many vehicles used by criminal organizations to launder their illicit obtained money. The real estate sector merits close consideration given the large scope of monetary transactions, its significant social impact, and because of the number of cases in which money laundering and in limited circumstances, terrorist financing and tax fraud schemes have been detected. All area members must be FIU registered. However, the lacuna exists that not all real estate agents are members of area, and therein lies the problem. Madam President, if you permit me, let me, from a real life experience as well, to paint a picture of how dangerous an unregulated industry as this one could have on unsuspecting members of the public. Throughout the length and breadth of Trinidad and Tobago, one must only just simply take up a leisurely drive, and you would recognize the amount of properties within our country that are dilapidated in nature, that many persons aren't aware as to who the owners are. And if they had some inkling or an iota of an idea as to who these people are, the most they could tell you is that, I know that person, I think his name is Jim. he was around when I was a little boy. I suspect that he may not be in the country. And what happens is that there are persons who pretend to be real estate agents who would take that leisurely drive, identify these properties that exist throughout the length and breadth of our country, and then go down to the land registry, because it's a public registry, procure the deed information for that property, and then start to pass the property off as they themselves are a real estate agent acting on behalf of this owner who is no longer present. And what you would find happening is that persons have gone as far as procuring false identification cards in the names of the owners of the property, procuring bills attached to an address in the name of the owner of the property, and then engage in an actual conveyancing transaction where unsuspecting, as the law recognizes them in some instances based upon the defense raised, unsuspecting bona fide purchasers would come, engage in the transaction, make a purchase of the property, and then only later on, in some instances months, some instances years after, because the statute of limitation on fraudulent transactions rarely occurs subsequent to the aggrieved party understanding that they have been defrauded, years later take action against these bona fide purchasers. And I thought to myself when I was a part of a matter that had engaged the court's attention with related facts and circumstances, that why would someone engage in that level of fraudulent activity? Taking the driver on, procuring the deed, getting the fraudulent ID card, getting the fraudulent signatures and the fraudulent bill to demonstrate proof of address. Why would someone engage in that level of fraud? To actually engage in that level of fraud. And I was told by the member of the fraud squad when we reported the matter, well, Chief, you have to understand, this particular man in your client's case made away with $800,000. $800,000. And his output to so procure those funds may have cost him $40 in gas and a $2,000 or $5,000 to bribe whoever it is he had to bribe to get the ID card and to get the bill in his name. $800,000. And thankfully, as a country, recognizing that this is an unregulated industry and that these acts of fraud could constantly occur, most of the stakeholders within our country have taken the approach or adopted the approach in some instances to create situations or create processes to limit the amount of fraud in those situations. So an unregulated industry like the real estate industry is a huge, huge problem. It has been for quite some time. The example that I gave is something that in some instances still occurs. I expect that the current number of fraudulent reports to the fraud squad in Trinidad and Tobago has risen exponentially, and the amount of monies that persons have been defrauded would concurrently rise as well. In looking at the bill itself, as Madam President, I focused throughout the length and breadth of the bill, but I would like to begin on page 12, which section 12.3, and there's also a similar provision on page 16, section 19.5. And these two provisions deal with the appeal process. Now, the bill contemplates the setting up of different committees throughout, a disciplinary committee, a licensing committee, the Registrar General having the power to actually register real estate agents as well too. And in consultation with some real estate agents, what they would have indicated is that they didn't understand why the appeal process couldn't have gone to one of these committees as opposed to going straight to the High Court. They were concerned as to the costs that would have been connected with this particular appeal process. And what we have to understand and appreciate is that a lot of real estate agents, or the practice of being a real estate agent in some instances, because it has been unregulated for some time, is an ad hoc practice. So there may be persons who may be properly aggrieved, but really don't have the money because they are one of the smaller real estate agents who do this as a side practice or something that may not be able to afford this process of appeal that is envisioned here through these two particular sections. I also looked at page 15, clause 16.2. Now, clause 16.2 deals with the actual registers being created by the Registrar General's Department. And it calls for a payment of a fee by the public to access this register. And I'm thinking if we are moving towards regularizing the industry, especially to the benefit of both the real estate agents and to the public, it may be beneficial that this particular registry is one, free for any member of the public to walk off the street to see who are registered real estate agents, so they will know that the individual or individuals that they are treating with are bona fide in nature. As well as I'm thinking, especially because it has been touted by this particular administration that they are moving to have many services online, that the registry should be accessible online as well too. So persons can stay from the benefit of their home and access the registry. The registry as well too in this particular section deals with the payment of a fee by the real estate agent in the event that they want to change or delete some aspect of their registration. And I think to place some type of charge on that may not be as beneficial as we would think it is. It's cumbersome. It's not as tidy as the rest of the bill would want to proffer itself to be. Further down at on page 15, clause 16.5b, allows for the access of that private registry by certain entities. A is the supervisory authority, but B is simply for the purposes of law enforcement or court proceedings. And I can understand pursuant to an order of the court or where required under any written law, but just to have it simply as for the purposes of law enforcement, as opposed to the purposes of law enforcement once a warrant has been procured. It leaves it extremely wide and available for any member of any law enforcement agency to access that private registry. And I think it defeats the purpose of having sufficient checks and balances in place for that access to be limited in nature. I listened to Senator Hussain speak about the composition of the committees, both the disciplinary committee and the licensing committee, and I would definitely have to agree with his submissions. I won't go into them because I think he dealt with them as comprehensive as they can be. But simply to add that if we are in fact creating or regularizing an industry, there must be some level of buy-in or participation by the persons who would so be involved. And I think in terms of the experience allotted to some of these brokers and real estate agents who would be allowed to sit on these committees, the experience there is 5 years. I mean, there are many persons within this industry who have been practicing this particular profession for decades. So I thought that the experience level of those persons should be increased as well. So there should be more buy-in by them, more participation by them at the level of these committees, and then the experience level should also be raised a bit. Now, I also looked at page 22 of the bill, and page 22 dealt with the section clause 35B, dealt with the termination of a member of the committee. That termination aspect also exists at page 36 when you deal with the disciplinary committee and the termination of persons or members there as well. And at part B, it simply says for any other reasonable cause. There's a flow, a process in itself with respect to the offenses that can be committed by members of these different committees that would warrant proper termination. We have to remember that these persons would be operating in conjunction with some type of relationship with a minister.
Senator Sobers, you have 5 more minutes.
Grateful, please, yes. And so I thought for any other reasonable cause seemed to be extremely wide. And when persons are engaged in these type of regulatory positions, security of tenure is extremely important because you're going to be in relations with many persons who would be part of the organizations themselves, and you wouldn't want to be making certain decisions and have this guillotine hanging over one's head that you can in fact be removed for something as wide as any other reasonable cause, which there are many iterations of that could fit in with that particular clause there. So I think it should actually be removed, as it seems to affect, in my humble opinion, a person's ability to discharge their functions reasonably enough. Now, there was also a view expressed by certain individuals with respect to the association having to fit the cost of the secretary for the committee, having to fit the cost of the office staff in terms of the disciplinary committee as well too. Persons were very opposed to that, and they indicated that this should be a cost borne by the minister or the ministry themselves, as opposed to the association itself. Now, Senator Hussain touched on clause 47, which is located at page 28. Now, clause 47 is the disciplinary committee clause, and what it deals with, professional misconduct, as a matter of fact. Now, in terms of duality of agents, Senator Hussain touched on the fact that there are situations wherein one agent would in fact act for both the vendor and the purchaser. And he is correct. In England, it isn't, once that individual declares his or her interests, it's generally okay once there's no duality of fees being charged by the agent on both parties. But what is not contemplated here is that there are many firms within our country, valuation firms, that also double as real estate agent firms. And I wouldn't want to name some of those firms, but what happens is that you would visit this firm who would tell you that they will look for real estate for you, and they will find certain properties or whatever the case is. And then when it comes time for you to take your mortgage or to conduct the purchase, and you have to procure a valuation, they offer the service to you as well. And in some instances, it could be seen as being mischievous that the valuation that they utilize or that they give to you is not in your best interest and does not reflect the actual value of the property. And I'm thinking that that should also be something that is looked at and regulated properly, that you cannot be acting for the seller or the purchaser, looking for real estate for them, and then also providing them with a valuation report. Yes, valuations move along a more scientific and calculated approach, but still there has been elements of mischievousness that have been found to rear its ugly head when one firm is actually doing both jobs. On page 37, there's also the issue of the disciplinary committee proceedings. That's clause 63 and clause 63.1 and 63.3. And it deals with where a complaint is being made by an aggrieved individual against an agent. It does not speak to the complaint actually being done in an affidavit form, and in the disciplinary committee of the Law Association, it is done like that. In closing, there are some things that we can tighten up, and at committee stage, I will definitely raise them. Madam President, thank you for allowing me to contribute today.
Honourable Senators, we will now suspend the sitting and return at 1:40 p.m. So this sitting is suspended until 1:40 p.m. when we resume. Senator Deonarine will begin with her presentation.